unenforceable law is said to be void. Now, my lord, this agreement is an agreement under the Arbitration Act. Now, Section 17.
This is an agreement under Contract Act.
Yes.
Put it into arbitration law.
Yes, yes.
There cannot be separate agreement under Arbitration Act.
No, my lord, then Arbitration Act will become unenforceable at all. If it has to be, my lord, the whole purpose and reason for having Arbitration Act will be lost. If an applicant is sent for impounding, my lord, under the Stamp Act, the whole purpose and intent for having this.
We follow your line of argument.
Yes.
Next, what is your point?
That's one point, my lord. Your lordship may have a look at another aspect. Page 88, my lord. Page 69, my lord. At page 85, my lord. Yes. Paragraph 54, ma'am. Yes. As I mentioned below, one of the main objects, paragraph 55, ma'am. Page 85, yes. Paragraph 55, ma'am. Yes. Second, the plain language of Section 7 once again governs my conclusion. Section 7 does not require that the parties stamp the agreement. It would be incorrect to disturb Parliament's intention when it is so clearly stated and when it is in no way conflicts with the Constitution. 57, my lord. Quote, Section 7(4)(b) states that an agreement is in writing if it is contained in an exchange of letters, telex, telegrams, or other means of telecommunication which provide a record of agreement. Then, my lord, paragraph 59. The court has to translate the legislative intention, especially when viewed in the light of one of the Act's main objectives. To minimize the supervisory role of the courts in arbitral process, statements of objects and reasons in Section 4 the Act, if the court adds a number of extra requirements such as stamps, seals, and originals, we would be enhancing our role, not minimizing it. Moreover, the cost of doing business would increase. It takes time to implement such formalities. What is even more worrisome is that the parties' intention to arbitrate would be foiled by formality. Such a stance would run counter to very idea of arbitration, where tribunals all over the world generally bend over backwards to ensure that the parties' intention to arbitrate is upheld. Adding technicalities disturb the parties' autonomy of will. In the next para, technicalities like stamps, seals, and even signatures are red tape that have to be removed before the parties can get what they really want. An efficient, effective, and potentially cheap resolution of the dispute. Then, my lord, the maxim autonomy de la volonté doctrine is enshrined in the policy objectives of the United Nations Commission on International Trade Law, Ancestral Model Law, and International Dispute. The courts must implement legislative intention. It would be improper and undesirable for the courts to add a number of extra formalities not envisaged by the legislation. The court's
technicalities, stamping is said to be a technicality. Court should get rid of it.
Technicalities in the sense, my lord, while putting the machinery under the Arbitration Act in motion, my lord, the machinery under the Stamp Act can be taken care of. My lord, machinery under Section 11 can be initiated, subject to, my lord, invoking the machinery under the Stamp Act. Then, my lord, your lordship may have a look at page 100, my lord. Commissioner Income Tax versus Hindustan Bulk Carrier.
Yes.
It starts at page 100, man. At 106, 116, man.
Yes.
116. Paragraph 14, man. Your lordship got it. A construction which reduces the statutory of futility has to be avoided. A statute or any enacting provision therein must be so construed as to make it effective and operative on the principle expressed in the maxim. Liberal construction should be put upon written instruments so as to uphold them, if possible, and carry into effect the intention of the parties. Then, my Lord, para 68, the courts will have to reject the construction which will defeat the plain intention of the legislature, even though there may be some inexecuted in the language used. Para 17, if the choice is between two interpretations, the narrower of which would fail to achieve the manifest purpose of the legislation, we should avoid the construction which would reduce the legislation to futility and should rather accept the bolder construction based on the view that Parliament would legislate only for the purpose of bringing about an effective result. The statute must be read as a whole, and one provision of the Act should be construed with reference to other provisions in the same Act so as to make it consistent with the whole statute. The court must ascertain the intention of the legislature by directing the attention whenever it is possible to do so, it must be done to construe the provisions which appear to conflict so that they harmonize. It should not be lightly. Yes.
Have you come across any judgment
Yes.
where there is a discussion of contract act, stamp act, and the arbitration act?
No.
Together?
Only Garwari.
Only Garwari.
Only Garwari is there.
Only done. But my respectful submission is, my Lord.
Because this Bhandari's order which you are citing,
Yes.
it is in reference to a concluded contract. Parties have
Yes. Yes. Yes.
There is no concluded contract.
Yes, my Lord.
So where you asking for us to go for arbitration?
Yes.
Only in that context.
That context. Yes. Yes. My Lord, only intention behind having
That's
the
correct. That's
arbitration.
correct. That's correct.
My Lord, page 69, my Lord, for a second. My Lord, with respect to section 7 of the arbitration.
Page 69.
Page 69.
It's in your body.
And you have already read section 7.
Yes.
That you have understood. There is also
One.
same.
Yes.
That you can.
Yes. Yes.
Which is the other one?
Page 147, my Lord. My Lord, this is also as regards the when special act and general law, my Lord. Then the other one, my Lord, Queen's bench, my Lord, on harmonious construction.
Mr. Reddy, for stamp law, for stamp act, which is a special law? Stamp act or the arbitration act?
Arbitration Act. And Stamp Act applies to
If a
everything.
document is to be instrumented with stamp.
Yes.
Stamp law is a special act or the arbitration act?
Then it comes special act, my Lord. Both are special, my Lord, and it
You are right, both are special.
Yes.
Now, who is special over, who is special is?
my Lord, it has to be harmonious construction, my Lord.
In the latest special law.
Yes. Yes. And my Lord, just one section, my Lord, of the Arbitration Act.